Yo, what's going on, B? Today we're going to be reading Supreme Court rules states can eliminate insanity defense. The Supreme Court on Monday ruled that states can effectively eliminate the insanity defense for criminal defendants who suffer from mental illness. That I agree with, because using insanity as an excuse for committing any crimes, that's not going to fly. No. The 6-3 ruling holds that a Kansas law preventing the exoneration of defendants who claim a diminished mental state is not unconstitutional. That I agree with, just as I think it falls in a similar line to you being ignorant to the law. That means you didn't know. It's the same thing as, oh, I'm insane, so I don't know what I'm doing. Either way, it's not an excuse to commit a crime. In an unusual alignment for the bench, Justice Elena Kagan, considered among the more liberal justices, wrote the majority opinion and was joined by her 5 conservative colleagues. 3 liberal justices, Stephen Breyer, Soni Sotomayor, and Ruth Bader Ginsburg, dissented. Yeah, you're going to have people that's going to disagree for the simple fact that they want to push their beliefs out to everybody else. So, defining the precise relationship between criminal culpability and mental illness involves examining the workings of the brain. Yeah, you're not going to really know what a person's really thinking or what their purpose is. The purposes of the criminal law, yeah, you're not going to know that either. And the ideas of free will and responsibility. Kagan wrote, it is a project demanding hard choices among values in a context replete with uncertainty, even at a single moment in time. Yes, it's very uncertain to judge someone's character by doing a simple brain scan. Yeah, you're not gonna be able to decipher what was the sole purpose of someone committing a crime is, unless they tell you themselves. And if they do tell you, they might be lying. And it is a project, if any is, that should be open to revision over time as new medical knowledge emerges and as legal and moral norms evolve. Which is all to say that it is a project for state governance, not constitutional law. Exactly. Kansas law prevents defendants from arguing that their diminished mental state impaired their ability to understand right from wrong, and that they should not be held criminally responsible for their offenses. Okay, so if I am mentally unstable and I've committed repeated crimes over and over and over again, then I'm not culpable, because even though I committed the same crimes over and over and over again, I'm just mentally unstable. And that leads to me getting away with doing a crime every time. Okay. Under the law, defendants can still argue that they lacked the necessary intent to commit the crime, and can use insanity to ask for reduced sentences. Bull crap. No. That should not be used to reduce a sentence. If anything, you should seek help if you have a mental issue. The law was challenged by James Caller, who in 2011 was sentenced to death for killing his 2 daughters, his estranged wife, and his wife's grandmother in a 2009 rampage. His lawyers had unsuccessfully argued before the trial that the state law preventing Caller from using the insanity defense was unconstitutional. Caller also presented evidence of insanity at sentencing after his conviction, but the jury imposed the death penalty. 4 other states, Alaska, Idaho, Montana, and Utah, have adopted the same rules about the insanity defense. Caller's lawyers argued to the Supreme Court that the Kansas rule undermines a long-held legal principle. The rule defines a fundamental, centuries-old precept of our legal system. People cannot be punished for crimes which they are not morally culpable. And so they're not morally culpable. That means they can get away with their crimes? Is that what we're saying? So, even how can you account for that? How can you account for someone's morals when they're showing you time and time again that they're committing these crimes, regardless of whether they are mentally stable or mentally unstable? You can't let mentally unstable roam around free. Breyer wrote in a dissent that the rule effectively administers an arbitrary disparity over who can argue insanity. He presented a hypothetical contrasting two different mentally ill defendants. The first was shown at trial to have killed someone because they were convinced that the victim was a dog. No. Regardless of what happens to a dog, you cannot kill a person just because they've harmed a dog. That does not make any sense. And the second killed someone out of the belief that a dog ordered them to. No. No. The second one shows that you have an intent to kill because you were ordered to kill. So you're basically opening yourself up to being a criminal. Under Kansas change law, the defendant in prosecution 1 could defend against the charge by arguing that his mental illness prevented him from forming the mental state required for murder and intentional killing of a human being. Just as any defendant may attempt to rebut the state's prima facie case for guilt, Breyer wrote. The defendant in prosecution 2 has no defense, he continued, because he acted with the requisite level of intent. He must be convicted regardless of any role his mental illness played in his conduct. That I agree. That I totally agree. So I think it's a good thing for the Supreme Court to eliminate insanity as an excuse, as a defense to committing a crime, for the simple fact that anyone could use that as a defense to get a reduced sentence whenever they commit a crime. So good on you, state. All right, B, I'm out. Peace.